Hello everyone, once again welcome back to my channel. Today we are going to talk about intellectual property business. It is one among 9 relevant activities of economic substance regulations. If you are new to economic substance regulations, I would suggest you to watch my previous videos on ESR, where I am explaining the background and other relevant topics about ESR. The link to those videos are mentioned in the description box below. So let's check out today's contents. So these are the topics that we are going to discuss today. Definition of intellectual property business, core income generating activities of intellectual property business, examples of intellectual property business, definition of high risk intellectual property licensing, and example for high risk intellectual property licensing. So what is an intellectual property business, or when can we say that a business is regarded as carrying on an intellectual property business? A UAE business is regarded as carrying on an intellectual property business if they holds or exploits or receives gross income from intellectual property assets. So this is the definition given to intellectual property business as per the economic substance regulations. So the definition is saying that if a business is holding or exploiting or receiving gross income from intellectual property assets, then they are considered as carrying on an intellectual property business. So now let's see what is an intellectual property asset. An intellectual property asset is defined as any intellectual property right in intangible assets such as copyrights, patents, trademarks, brands, and technical know-how from which the licensee earns separately identifiable income in the form of royalties, licensee fees, franchisee fees, capital gains, and any other income from the sale or exploitation of the intellectual property asset. So an intellectual property asset is an intellectual property right in intangible assets, and intangible assets can be copyrights or patents or trademarks or brands, and if a licensee is earning separately identifiable income from these intangible assets, and the income can be in the form of royalties, licensee fees or franchisee fees or capital gains, in this case the business is regarded as carrying on an intellectual property business. So basically, if a licensee is earning separately identifiable income like royalties or licensee fees from intellectual property assets like patents or copyrights or trademark, then the licensee is regarded as carrying on an intellectual property business. Most of the UAE businesses will own some form of the intellectual property assets like their trademark or technical know-how relating to their process or copyright of their works, etc. But they don't earn separately identifiable income from such assets. Instead, the intellectual property assets contribute to or protect the value of the goods or services these businesses provides. In such cases, the ownership of such intellectual property asset would not be considered as carrying on an intellectual property business, as the intellectual property asset is merely auxiliary to the main business of the UAE business. So in short, we can say that if a UAE business is earning separately identifiable income from the sale or exploitation of intellectual property assets, then it is regarded as carrying on an intellectual property business. So here the important aspect is separately identifiable income from the sale or exploitation of intellectual property assets. So now let's look into the core income generating activities of an intellectual property business. The economic substance regulations set out certain core income generating activities for an intellectual property business. The core income generating activities required to be undertaken in the UAE will depend on the nature of the asset being exploited and how that asset is being used to generate gross income for the licensee. So the core income generating activities of an intellectual property business are research and development, branding, marketing and distribution. So when you say research and development, it includes planning and documentation of new product or process or services, prototyping, demonstrating, piloting or testing of new or improved technologies, addressing technological obstacles, applying research findings or other knowledge for producing or introducing new or improved materials, devices or products. So this basically talks about researching and development of new products or processes or service, or improving technologies, or addressing known scientific or technological obstacles and so on. The next one is branding, marketing and distribution. So when we say branding and marketing, it includes advertising, seeking endorsements, artistic design, developing consumer awareness, etc. And when you say distribution, it includes distribution of marketing intangible through various mediums such as on-demand services, business-to-business sectors, integration into IT systems, creating dealership networks, and so on. So basically these are the core income generating activities of an intellectual property business. Also, one more thing to add on, in demonstrating economic substance in the UAE for an intellectual property business, periodic decisions made by non-resident directors would not be sufficient to satisfy the economic substance test. So now let's discuss some examples so that you will get better understanding about intellectual property business. So moving on to our first example, ABC company holds a brand, the rights for which are licensed to others in return for a royalty. So whether ABC company is within the scope of intellectual property business. So going back to the definition of intellectual property business that we learned, a licensee is considered as engaged in an intellectual property business if they are earning separately identifiable income from the sale or exploitation of intellectual property assets. And in this example, ABC company is earning royalty for its brand, and hence ABC company is within the scope of intellectual property business. Let's discuss our next example. Chocolate company has a trademarked range of chocolates which it manufactures and sells to unrelated third parties. So whether chocolate company is within the scope of intellectual property business. In this example, the chocolate company is not an intellectual property business as its gross income is derived from the sale of finished goods to third parties and not from the exploitation of intellectual property assets. In this example, the value of the trademark is linked to the value of chocolates and is not separately identifiable, making the use of the trademark incidental. And hence chocolate company is not within the scope of intellectual property business. So now let's discuss one more example. Software company has developed a unique IT software platform for accepting, processing and tracking online orders that it holds and uses within its own business of online marketing. Software company also licenses the IP software platform to others to use within their online marketing business. The users pay software company a license fee in order to use the IT software platform. So whether software company is within the scope of intellectual property business. So in this example, the software company has shared the IP software platform to others and the software company is earning a license fee for that. And hence software company is within the scope of intellectual property business. So now let's discuss what is high-risk IP licensee. So intellectual property business are of two types. One is normal intellectual property business and the other one is high-risk intellectual property business. So we already learned about normal intellectual property business. Now, so for a normal intellectual property business to be classified as a high-risk intellectual property business, it needs to satisfy either of the two conditions given as per the definition of high-risk IP licensee. So let's discuss those two conditions. So the first condition has got 3 sub-points. So we'll discuss the first condition that has got 3 sub-points, and that intellectual property licensee should satisfy these 3 sub-points to be classified as a high-risk intellectual property licensee. So the first condition is that the licensee did not create the intellectual property, and the licensee acquired the intellectual property either from a connected person or in consideration for funding, research and development by another person situated in a country other than the UAE, and the licensee licenses the intellectual property asset to one or more connected persons or otherwise generate income from the asset in consequence of activities performed by foreign connected persons. So if an intellectual property licensee is satisfying all these 3 conditions, then the licensee is classified as a high-risk IP licensee. So we'll discuss the first condition one more time, that the licensee should not create the intellectual property. The licensee should have acquired it either from a connected person or acquired it by paying a consideration for funding, research and development to another person who is situated outside UAE, and the licensee licenses out the intellectual property asset to one or more connected persons. So if these 3 conditions are satisfied, then a normal intellectual property business will be classified as a high-risk intellectual property business. And the second condition is that the licensee does not carry out research and development or branding or marketing and distribution as part of their state core income generating activity. So this is the second condition. So either of these conditions should be satisfied for a normal IP business to be classified as a high-risk IP business. And any high-risk IP licensee by default is deemed to have failed the economic substance test, resulting in the competent authority exchanging information on high-risk IP licensee with the relevant foreign competent authority. So, like I explained before, either of these 2 conditions should be satisfied by an intellectual property business to be classified as a high-risk intellectual property business. So I hope the definition of high-risk intellectual property business is clear to all of you. So like I said before, any high-risk IP licensee is by default deemed to have failed the economic substance test, resulting in the competent authority exchanging information on the high-risk IP licensee with the relevant foreign competent authorities. Also, a high-risk IP licensee would nevertheless be required to meet the economic substance test to avoid being subject to penalties by providing sufficient evidence supporting that it has and has historically had a high degree of control over the development, enhancement, maintenance, protection and exploitation of the intellectual property asset. Also, the licensee is required to have an adequate number of full-time employees with the necessary qualifications who permanently reside and perform their activities in the UAE and would need to provide the following information, like a business plan showing the reason for holding the ownership of the intellectual property asset in the UAE, employees' information including the level of experience, type of contracts, their qualifications and duration of employment of the licensee. The above information would have to prove that in the UAE there is more than local staff passively holding intangible assets whose creation and exploitation is a function of decisions made and activities performed outside the jurisdiction. As such, the business would need to evidence that decision making is taking place in the UAE. Also note that periodic decisions made by a non-resident director or a board member would not be sufficient for this purpose. So I hope with this you got a better understanding about high-risk IP licensee. So let's discuss one example for high-risk IP licensee. Pharma Corp LLC, a UAE resident company, earns gross income from licensing its patent for a new medicine to its group companies located in Egypt and KSA. Pharma Corp did not create the patent. The rights were acquired from a group company named R&D Company in the UK. So whether Pharma Corp is a high-risk IP licensee. So in this example, the Pharma Corp did not create the patent. It acquired the rights from its group company and it is earning gross income from licensing that patent to other group companies which is located in Egypt and KSA. So it is very clear that Pharma Corp is a high-risk IP licensee. And as per the regulation, it should provide additional information to evidence its economic substance in the UAE. And also the competent authority will exchange this information to the foreign competent authority. So I hope with this example you got a better understanding about high-risk IP licensee. So let's summarize today's session. Today we discussed about normal intellectual property business and also high-risk intellectual property business. A business is regarded as carrying on an intellectual property business if it is earning separately identifiable income from an intellectual property asset. So here the main focus should be on separately identifiable income. If no separately identifiable income is earned from an intellectual property asset, then that business is not regarded as carrying on an intellectual property business for the purpose of economic substance regulations. Then also we learned about high-risk IP business. If an intellectual property is satisfying either of those two conditions which we discussed, then that normal intellectual property business will be classified as a high-risk intellectual property business. And with this we have reached end of today's session, and I hope this session was useful to all of you. Thank you so much for watching. We'll see you in the next session. Take care. Bye bye. Stay safe.